I'll talk a little bit about guardianships. If you have a child that's disabled, and many of you know that the definition of disability continues to grow as people in the government learn more about the nature of disability, what causes it, and how people live with disability. So I won't go into the great detail about defining that term, but if you have a child with a disability, generally you'll be their caretaker financially and personally. You'll be responsible for taking care of that person just like any other parent would be responsible for taking care of their child. But once that child turns 18 and they're legally an adult, there may be some individuals that require so much care or have a disability that's so severe that they may not be able to act on their own behalf. What happens in a guardianship is you will first go to court and you will ask the court to, you will petition to the court to have them make a legal declaration that the person is in fact incompetent, and they'll go through a number of proceedings. They may require testing, and oftentimes there will be some resistance from the person upon whom you're trying to get this guardianship placed. And so they may get their own lawyer and try to fight you from becoming their guardian. That happens more often than you would think. With this petition to have that person declared incompetent, and if that court does grant that petition, then the court will then ask to have people apply to be the guardian. And there's a number of different types of guardianships. There is a general guardian, there is a guardian of the person, there's a guardian of the estate, and then there's something called a limited guardianship. General guardianship just means that the court will appoint a guardian, and that person will essentially step into the shoes of the person that has been deemed incompetent, and they will be able to make all financial decisions. They'll be able to make all decisions relating to health care and basically manage every aspect of that person's life. Guardian of the person and guardian of the estate is 50% each of a general guardianship. So if you're a general guardian, you're responsible for the person and you're responsible for the estate. Sometimes the court will split those responsibilities and appoint a guardian of the person to manage the personal care of the disabled person, and appoint another person to manage the estate, which is essentially the financial affairs of the disabled person. And the last thing is a limited guardianship. That's where the court allows the person to retain certain legal rights, such as the right to vote, and basically anything you can provide evidence for in the petition. So depending on the nature of the disability, any one of those might apply. In administering a guardianship, that is a long-term process. You are appointed the guardian, and you remain the guardian until the court removes you or until that person dies. And that is it's a pretty significant process. You have to account to the clerk of court for essentially everything that comes in to that guardianship estate. You have to account to the clerk of court for everything that goes out. And keeping good records is paramount for everything that I'll be talking about tonight, especially guardianships and especially special needs trusts. But going through the process of dealing with the clerk of court is something that people will try to do on their own, and that's how a lot of clients end up in our office, is because they have tough times dealing with the clerk of court. They're really specific, they're down to the penny, and they won't let you proceed unless you get it exactly right, so it can create a lot of hardship for families. When a child is younger than the age of 18, the state sees the child as the responsibility of the parent, and the parent has all of their parental rights until the child reaches the age of majority, which is 18. Upon reaching the age of 18, you would have to apply for a guardianship. And in fact, that brings me to a good point, which is that you can have guardianships for a minor. If a minor becomes entitled to funds, if you died and left your child without a will and your child inherited any amount of money from you, the court would require you to set up a guardianship to hold those funds of that child until he or she turns the age of 18, at which point the guardianship is closed and all the money is paid out directly to the 18-year-old kid. There's a number of rules that disqualify people from being guardians. One thing that really prevents people from becoming guardians, they'll go through the process of having the determination hearing of competency. They'll get to the point where the clerk asks to have a guardian appointed. You'll submit your application, you'll say you're the mom or the dad, and you'll show your criminal record is clean, and then you'll go to get bonded. All guardianships of this nature require a bond. A bond is simply an insurance contract issued by an insurance company saying that if you run off with the money, then the insurance company will compensate the guardianship estate to protect the assets in that guardianship estate. And when people go to get a bond, sometimes they get rejected based on their credit. So depending on the amount of assets in the guardianship, the bond relates to the size of the estate. And oftentimes people will be denied bond based on their credit. And then the parent's stuck with this guardianship proceeding that's already 75% of the way through, and now they're looking for someone that can qualify to be the guardian, someone who can get bonded, and that can be a troubling issue for them. Anyone can apply to be a guardian, and they will often appoint more than one guardian. You can have co-guardians, so a father and a mother could be co-guardians. Sometimes they may split those roles. What happens in a situation where a guardian passes away or is no longer able to serve? The answer to that's pretty straightforward. The next person to step up is someone else from the family or someone closely related to the family or someone of a trust position would apply to be the guardian, and the guardianship would continue.